Bail, pre-trial procedure. All criminal offenses must then be brought to the Magistrates Court. However, it is rare for a trial to be decided at the first hearing, while it is common for small charges to be dealt with at that stage. That will probably happen if the defendant pleads guilty and is either professionally assisted or does not want to seek legal counsel. There is a specific process for certain driving charges, which requires the suspect to plead guilty by letter, meaning that no appearance at the trial is required. And in these situations, the magistrates can continue to delay the trial in order to collect more details about the offender. 1. Categories of offenses. 1. The sort of offense, which is being handled with, impacts the type and number of pre-trial proceedings where the final trial will be held. Criminal charges are classified into 3 primary groups. These are the following. A. Summary offenses. These are the least severe offenses that are often prosecuted before the Magistrates Court. These cover nearly all traffic offenses, serious abuse and criminal harm that have done fewer than £5,000 worth of injury. Anyone who commits a summary offense usually faces a fine or community service. However, even if it is a summary offense, falling into the category of triable either way offenses, the chances are that the magistrate will send your case to the Crown Court. B. Triable either way offenses. These can be considered to be the center spectrum of crimes, include a wide variety of crimes, like theft and assault, which actually cause physical harm. Because the name suggests, these lawsuits can be taken to either the Magistrates Court or the Supreme Court. C. Indictable offenses. Those are the most serious offenses, including homicide, kidnapping and rape. Any indictable offenses will be heard before the Crown Court, although the first examination will be in the Magistrates Court. The dispute is then referred to the Crown Court. With indictable offenses, the defender may have to face imprisonment with a fine. It is very serious, and the English legal system does not take it lightly. 2. Pre-trial procedure for summary offenses. Cases may be dealt with at first arrival in court, although sometimes an adjournment will be required. That may be that the Crown Prosecution Service did not provide all the evidence available to prosecute the trial, or that the complainant requested legal counsel. Another justification for adjournment of the trial is that the magistrates provide pre-punishment reports of the person who pleads guilty before determining what punishment to implement. When the defendant wants to argue not guilty, there will nearly certainly have to be an adjournment, because the evidence would have to be called to the trial. One of the key issues to be determined on an adjournment is that the suspect will be put on bail or in detention. Early administrative hearings. In order to eliminate excessive disruptions, the first hearing is now an early administrative hearing, EAH. The trial can be held by a single lay judge, or perhaps by the clerk of the court. The aim of the proceeding is to figure out if the defendant wishes to qualify for legal assistance and, if so, to figure out if he is qualified for it, to seek pre-sentence or psychiatric records if they are appropriate and to determine if the defendant will be held in jail or on bail. There is a restriction on the powers of the clerk in this case, as the clerk cannot alter the terms to which bail has already been issued. 3. Cases going for trial at the Crown Court. Triable either way offenses. For these, there will be further hearings at the Magistrates Court. The defendant will be asked whether he pleads guilty or not guilty. If he pleads not guilty, then a decision has to be made as to whether the case will be tried in the Magistrates Court or the Crown Court. Indictable offenses. Certain indictable offenses shall be sent to the Crown Court directly pending an early disciplinary trial in the Magistrates Court. Such pre-trial proceedings are dealt with by a magistrate at the Supreme Court.